going to go ahead and get started back. We have Tripp Watson, who is the founder of the Watson firm here in Birmingham. Coming up, he's going to talk to you about Alabama's new LLC Act. Thank you, Mr. Watson, for being here.
Afternoon, everybody. Can I get an afternoon? All right, everybody's gotten through lunch. Everybody's fallen asleep. No, I am. I've got some coffee. So I know that we're through the home stretch and everybody's like, it's getting close to 4 o'clock on a Friday, and I just cannot wait to hear about some more corporate law. So today we're going to be talking a little bit about the new LLC Act, and I will try my best to make sure that y'all don't fall asleep. So just a little bit about me. I practice here in Birmingham. I do a lot of LLCs for startup companies, and so I see a lot of this stuff going on. And so this new act is pretty interesting for the way that it's set up. I do want this to be a little bit interactive, so if you do have any questions, feel free to stop me, raise your hand. And even if you have some personal experience with this, because the new law is still going, it's still very young. So if you've got some personal experience with some of this, that's probably good for everybody in the room, because we really don't know how this is going to look yet, even though we're still about 10 months in, because practically speaking, we haven't gotten to the point where there's been a whole lot of arguments about the way that it's going to be implemented. So if you've had some run-ins already, that's appreciated. And but anyway, so first things first, just to give you all a little bit of an overview of what we're going to be talking about. First off is a general history of LLCs. I'm a contextual person. I like to understand a little bit where we're coming from and why. Then we'll talk about the actual changes in the code. And then finally, what this is going to do for our choice of entity decisions when you've got somebody that wants to start a business or do something like that, how we're actually going to be structuring those. So the very first thing that we will hit on is the history of the LLC generally and of the law in the state of Alabama. The very first thing that you need to know about LLCs is that they're not originally from the United States. So the idea of a limited liability company comes from a German idea, a GmbH company. I will not even attempt to pronounce that, but anybody that can, bonus points. I'll give you a sticker at the end of the presentation. So basically, this was set up in 1892 in Germany. Basic idea was a very easy to manage limited liability company. We didn't really see anything like this in the United States until about the late 80s. And the reason for this is that in the United States, we developed a very thorough corporate law. The reason that corporate law in the United States has developed the way that it is because it's based on best business practices. You want to have divisions between shareholders, board of directors, officers. There's a little bit of internal accountability that comes in on that, and we've incorporated that into the corporation law. However, that's not necessarily the best form for every single type of business. So corporate law became pretty difficult to manage for small companies, and even companies that didn't have the ability or the budget to actually manage large transactions or internal operations. And so there became push for another type of legal entity that we started to see in 1977. So if you're keeping track of your history, this is pretty young law. Wyoming was the very first state to adopt an LLC law. Basically, an oil company was going into Wyoming and wanted to have limited liability, but they wanted to have a separate division in that state, but they didn't want to do all the headaches that you typically have to have for a corporate limited liability structure. So in 1977, they pushed Wyoming's legislature to put in what was then called a limited liability company, and basically it allowed them to shield their investment in Wyoming from potential liability if it were to blow up, quite literally. And they pushed it through the Wyoming state legislature because Wyoming said, why not? This is investment. It helps us out. The problem is that we really didn't know how this was going to be handled from an IRS standpoint until the 80s. So in 1988, we actually had clarification from the IRS, and the IRS said, listen, we've got rules for governing sole proprietors, we've got rules for governing partnerships, we've got rules for governing corporations. there's no reason to add another one to the mix. We're going to treat LLCs the exact same way. So after 88, you started to see an explosion of states incorporating or building in LLC laws because you had the benefit of flexibility in choosing your tax scheme. So not only did you get limited liability with low maintenance, but now you could pick whichever tax scheme you wanted to be in if you otherwise qualified for those requirements. So in 1993, Alabama puts in our first LLC Act, shortly 5 years after the IRS clarifies the tax structure, and that was the code, old Chapter 5, that got put in place, and it's only been amended once in 2011. So in 2011, we made some cosmetic changes to it. We kept the original Chapter 5, but we really didn't make substantial changes to it. So some of y'all are out here saying, didn't we just change the law? Yeah, we did. So it was not even a presidential term ago. So now we have the new change that came in 2014 that went into effect at the beginning of this year. So what we're talking about now is that we still have two laws on the books. We've got the old 2011 law that still exists, and now we have the new 2015 law that applies on companies that have joined since then and companies that have elected to be treated under the new law. So we'll talk a little bit specifically about what that means here in just a second. But practically speaking, the reason that LLCs have been attractive and the reason that they've been so successful, an overwhelming number of new legal entity setups that are not sole proprietors have been LLCs. And the main reason for that is that you get the benefit of limited liability. Unlike going into a business with a partner, where not only are you responsible for the debts of the company yourself, but you might actually be responsible for the debts of your partner, you now get limited liability for both of you. You get to have the foundations of partnership responsibility. How you actually run the business is governed by partnership rules. You also get less paperwork. You don't have to do as many annual filings. Every single time you change a member, you don't have to register it with the Secretary of State or the judge of probate. That can all be done legally, internally. And you also get the benefit of pass-through taxation, which is always great because who wants to pay more taxes? So LLCs have been very attractive for a lot of businesses that are looking to start up. And the reason is, like I said, when you're looking at the two other main forms, a limited partnership or a corporation, you can start it with as little as a single member, but you don't have to go through the headache that we've incorporated in the corporation laws that generally tend to be best business practices. A big misconception, and this is something that I run into a lot, is everybody says, well, yeah, LLCs are great for the guy that is going to throw some tools in a truck and just run around and do plumbing work, but it's not really for our business, and that's just not true, actually. So we have several businesses that have been nationally LLCs. So you have Chrysler, when they went through their restructuring, they stopped being an LLC. They're now part of, they're currently an LLC. America Online before 2008 was an LLC before they went public, and BMW's North America operations are formed as an LLC. So this is not just a form that we're using for small, closely held companies. We're seeing this in major multi-state, multinational companies. So don't assume that this is simply for the guy that has a plumbing truck. We're going to talk a little bit about the law itself. So now we've talked a little bit about the history. We're going to be diving into how the law actually works. In the state of Alabama, the corporate code is governed by 10A, which is the new law that went into the effect a few years ago. And the way that it's structured is a hub and spoke structure, which means that Chapter 1, the hub, governs all the rules that govern every other type of legal entity. They are the default rules for every other type of entity. It governs definitions, how they're set up, how they're run, how they're maintained, and even how they're shut down. Each one of the spokes come in each individual legal entity form to clarify the law or to even amend it or remove it. So, for instance, Chapter 2 will be business corporations, the traditional corporation form. It will build on Chapter 1 and clarify what, of course it's going to give you, sorry, trying to connect to the internet. It will clarify and build on Chapter 1 by saying what is actually required specifically for a corporation. Chapter 5 is the old spoke for LLCs that will be going away in 2017. The new one is 5A. So what's important to remember on this is that when you're looking at LLC law, you not only have to look at the individual code in Section 5 or 5A, you've also got to look at the old Chapter 1, which has some of the basic rules that get built on in the spokes. So for instance, if you have one of the big changes that's coming through is that, or has come through, is that LLCs do not have to state a business purpose. Even though Chapter 1 says that every legal entity formed in the state of Alabama has to have a business purpose, Chapter 5A comes back and says, actually, that's not necessary for LLCs. So, when you're looking at the code, be sure that you're looking both at Chapter 1 and at the spoke. So, hub and spoke situation here. Make sense? Good. Here's the overview of the new law as it's going into effect. It is called the Alabama Limited Liability Company Law of 2014. It was passed last year. It went into effect on January 1st of this year. What that means is that if you have filed an LLC, or if you have amended an LLC to be treated under the new law since then, it is treated by Chapter 5A, regardless of whether you want to or not. So if you thought you were traveling under the old 5 and you set up something in November, or you set up something last month, it's under the new 5A. Old businesses, old LLCs, will continue to operate under the old 5 until 2017. At that point, the old Chapter 5 is gone. It's repealed, it's no longer effective. Regardless of whether you want to be treated under new 5A or not, you're under it. Unlike a lot of laws, this is a law that has a legislative purpose. And so the interesting thing about 5A is that they've stated two very explicit legislative purposes. The first is that they are preserving the right to contract, and they are basically legitimizing what people were already doing. This is pretty dangerous, because what the state of Alabama has done is to say, listen, here's the law, we're going to provide some very basic default rules, but if you don't like them, we don't care. If it's in the operating agreement, if it's in the LLC agreement, it goes. So if you want to have a provision that says that Frank is on the board of directors and he doesn't have to show up and he gets paid $50,000 a year, and even if he steals from the company, he has no liability, that's fine. We're okay with that. The state of Alabama is not going to get involved in your operating agreement. What does this mean? The LLC is a very big trap for the unwary. If you don't know what you're doing, you're going to be getting into trouble. There are going to be some very savvy investors that are going to come in and take advantage in LLC rules. And the problem is that there's not default rules in the code section that's going to come back and protect minority owners in a business or somebody that's not sophisticated. So if you're going to be setting up an LLC, remember, if it's in writing, it goes. So don't be expecting that something's going to be held as going to be against or any type of provision is going to be thrown out based upon a default rule. The major changes, I can go through the individual code. In the materials I've provided the actual sections and compared them. I'm going to hit the high points here because it can get really annoying going through all the individual changes, and I know it's 3:30 on a Friday afternoon, and I'm not going to go through the individual code sections. I'm going to hit the high points. You can go through those yourself. But what's important to remember about the law is that Alabama started from scratch here. They looked at Delaware, they looked at some other states, they looked at the model rules and used them as suggestions. Alabama really started from scratch. So even if you look at the old code section, you'll realize that 5 does not match up with 5A. A lot of the provisions are thrown out entirely, and the ones that survive look absolutely nothing like the ones that were on the book before. The reason for this is like I said previously, the state of Alabama has basically said, we're going to do this our own way, we're going to draw some concepts from some other states, but really we're going to create our own law. So it'll be interesting to see if we become thought leaders on this or whether we just become another flash in the pan on the LLC law. The major changes that are coming through on the law, however, the biggest one is what's called a series LLC. Just by show of hands, who is actually familiar with what a series LLC is? Okay, about 50-50. That's about what I'd expect. I'm going to spend a little time talking about what an LLC, series LLC is, but suffice it to say that this is the single biggest change in the new law. That's my argument, at least. I think that this is one of the most appealing things about the new law. The problem is that y'all may have heard earlier from Bruce, there's a lot of tax implications here that we don't really know yet. And so we're still waiting to hear what happens on those. But from a legal standpoint and not from a tax standpoint, this is one of the most attractive things about the new law. Next thing is the operating agreement. The old operating agreement, what we called the operating agreement, is now being called the Limited Liability Company Agreement. I don't know anybody that's actually calling it that. It's the operating agreement. Everybody's always called it that. That's what people still call it. Technically, it's the new LLC agreement, but the operating agreement in the LLC now takes precedence. If you have something in writing in the operating agreement, and even if it's in contradiction to the law, the operating agreement controls. If the operating agreement is silent, then you look to the law. This is a big change. It used to be that there were some provisions you could not contract around. That's gone away. The reason that this is important is the fiduciary duties in the LLCs can be amended. Like I said before, that guy that comes in and gets paid $50,000 to sit on the board and he doesn't have to do anything and in fact can even just completely abuse the LLC, if it's in agreement that he doesn't have any duty to the company, that's fine. You can contract around that. So the default fiduciary rules that we used to have in the LLCs or even in corporations or partnerships can be contracted around. They're still there by default, but they can be amended so long as they're in an operating agreement. The catch-all on this, and it's going to be interesting to see how it plays out, is that for the first time, we've got a non-insurance bad faith cause of action. This is the last-ditch effort. If somebody says that they've amended away their fiduciary duties, we've now added in a bad faith action. That if we say that if this is not something that the operating agreement contemplated, we didn't have an agreement on this, we can now say that this is generally bad faith. The language of this particular portion is based upon the Delaware rule of the similar name. It's got a bad faith cause of action, but the law itself is so different from the Delaware rule, we don't really know if this is going to be controlling, preferential, or anything else like that. We don't know what type of precedents that this is going to make, because anybody that's familiar knows that bad faith has largely been restricted to insurance. So the addition of a bad faith action in an LLC context will be interesting moving forward, and we just don't really know how it's going to look yet. Some other changes that I wouldn't categorize as being the major changes, but other significant changes that need to be noted. Very first thing is that an operating agreement can now be oral or implied. I'm sure somebody in this room has set up an LLC before and told their clients, hey guys, you need to sign an operating agreement. Here's the operating agreement. Let's set a time next Tuesday to sign the operating agreement. No, seriously guys, let's set a time to sign the operating agreement. They don't sign the operating agreement. The old rule, you couldn't do that. Nowadays, you can operate for years under an implied oral operating agreement. Well, I was 50-50 and he got paid the same amount I did. We both put in the same amount of work. Our oral and implied operating agreement was that we were 50-50 partners. We never signed an operating agreement. New state of Alabama said, you know what, that's fine. That's the way y'all want to run your business, we're going to let you do it. This is going to create some problems in litigation, as you can imagine. Well, I thought we were 60-40. He thought we were 51-49. I thought that I had the ability to sign on behalf of the company. I didn't know that he did. How are these going to shake out? It's never been more important to sign an operating agreement, have something in writing, because you're going to have somebody that gets hosed here. I've got a situation right now where somebody's going to get hosed. And the problem is that because there's the new provision for oral and implied, this could be anything. It can be who's expected to show up, who's expected to sign on behalf of the company. It could be what your distributions are supposed to be. It could be how you get paid. It could be literally anything in the company. The other big thing is that we've actually put in a limitation of liability for a member in a breach of contract situation. So as often happens, say for instance you have a business that one of the owners happens to be a vendor or some type of customer or something like that, in which there is a contractual relationship between that member as an independent party and the LLC. You can now actually build into their operating agreement that if they breach a contract, that they may not be liable to the LLC as members. In that same scenario, say for instance we have a member that's supposed to show up to board meetings and they don't show up to board meetings, but there's a specific provision that says, you know, that would technically be a breach of the operating agreement, but that's fine, we're going to allow it to happen. There's going to be no liability for a breach of contract of the operating agreement. That can be completely fine. So you might end up having a completely formally written operating agreement that has absolutely no enforceability. The other big thing that we've added in, finally, I'm actually excited about this one, is penalties against non-performing members. It used to be that this was kind of in a gray area, depending on what your operating agreement was, but now we've actually put it in the code. If you got a member that's supposed to make a capital call, if you got a member that's supposed to show up to work, or if they're supposed to attend some type of board meeting, or if they're supposed to do something else that's in the operating agreement, and they haven't ditched their breach of contract responsibilities, then you can actually take away ownership from them. This used to be very contentious. It was very difficult to do, but now if it's in the agreement that says, listen, if you're supposed to make a $100,000 capital call 2 years out from the company and you don't do that, we're going to dock your ownership 20%. Completely legal now. It's explicitly provided for in the code. The code section's there. This is another big change.
Can you contract away those penalties?
Yeah. So you can say that so-and-so, member A is supposed to be the manager for the company. He is supposed to show up from 9 to 5, but there's no penalty for him not doing that. The other big thing is the changes in regards to the sharing of confidential information. Used to be old standby rule, you owned a company or any part of a company, you got access to the books. At the very least, that was one of the benefits you had. And a lot of times, that was one of the most valuable things that you could get. If you could take a peek at the books, that might be pretty valuable. LLC law says, if we're going to set up a class of owners, a class of members that does not have the right to see the books, that's completely fine. This is going to be interesting because you could end up having somebody, and like I said, that sophisticated investor who comes in and signs an operating agreement with the other owner saying that he owns 50% of the business he has no liability for a breach of fiduciary duty or breach of contract. He's the only guy that's able to see the books. But at the same time, if he were to violate any part of the operating agreement, he bears no liability for that. And that would be 100% legal. You would have a problem even being able to access the books if you were a minority shareholder in that business. So those are the big overviews. We're going to talk a little bit about the actual technical operation of the LLCs and how they've changed. Any big questions so far on the major changes that we've seen so far? All right. Big changes in terminology. So it used to be that you had the old member, manager, articles of organization, operating agreement, financial rights, and governing rights. The old way that this parsed out was members were people that owned the business. You had the option of being a member manager who managed the actual company. But the manager was somebody that could be appointed as an officer of the company. They didn't have to be a member. That's not changing, so that's a good thing. The other thing that we had is this caused a lot of confusion was what was the difference between the articles of formation and the certificate of formation. I got asked this question a lot. Practically speaking, the certificate was the piece of paper. The articles were the legal duties that they created. We've done away with that. We're just going to call it the certificate of formation. We just clarified that. The other big one is the operating agreement. Like I said before, the operating agreement was our old word for it. The new word for it is the limited liability company agreement. If you have your forms, go ahead and just update the forms and just say somewhere that any reference to the operating agreement also means the LLC agreement. Practically speaking, like I said, I have still yet to hear anybody formally call this an LLC agreement. Everybody still calls it an operating agreement. But technically the terminology has changed. It used to be that the rights that you had in the company were defined by law. There were two rights, financial rights and governance rights. I'll cycle through these. Financial rights were the rights to receive distributions from the company or otherwise have a financial interest in the LLC. Governance rights were explicitly provided for in that you had the right to vote or otherwise partake in the company. And these could be divided. You could actually say that somebody has financial rights and somebody else has governance rights, and there's no overlap. We've even seen more complicated class structures inside of LLCs since then. So the state of Alabama said, you know what, we're not even going to define these. We're just going to say that there's one transferable interest. You can define that interest internally however you want to, but from a legal standpoint, we're not going to divvy up what the individual rights are. The reason that this can create problems, obviously, is that if this is not defined in the operating agreement, who can vote on what, who gets distributions from what, when, this can obviously create some significant problems. The last thing is distributions. It used to be that from a legal standpoint, we had pretty complicated ways of structuring which way you were getting paid by the LLC. The state of Alabama is just now calling them all distributions. If you want to work with your tax accountant or your tax attorney to work out the specifics of how you're getting paid, but as far as the state of Alabama is concerned, every way that you're getting paid is called a distribution. Changes in the way that you form the legal entity. So this is the blocking and tackling of actually managing the LLCs. You still got to go and register the name with the Secretary of State. That's your first step, $28. Then you got to file the certificate of organization with the county. So you get your Secretary of State form, you take that and 3 copies of your certificate of formation down to the judge of probate, and you pay your filing fee. In Jefferson County, you write 2 checks, one for $100 to the judge of probate, $63 to the judge of probate, and $100 to the Secretary of State. Secretary of State does take credit card, just takes them forever to charge it. So, used to be that in the articles of organization, the old articles of organization, you need to have the LLC's name, the initial members in the company, and a business purpose. You don't need to have the initial members or the business purpose anymore. We've taken that out. You just have to have a short and plain statement that says that there is somebody that owns the company. You don't even have to identify who they are. The reason for this is if you don't want to set up some sham LLC that doesn't have any members. So at the very least, they want to have somebody that signed off on the bottom and said, listen, there is somebody that owns this. We're just not disclosing who it is. You also have to have an identification if you want to be a series LLC. This has to be listed in the certificate of formation. If you don't, anything that you do in your operating agreement is not valid. These are really the only things that you have to have on the certificate of formation nowadays. It's very easy to set up. The form on the form can be found on the Secretary of State's website. It used to be 3 pages, and it had a lot of boilerplate in there. Now it's 2. It's very easy to fill this thing out. Which goes back to that whole trap for the unwary situation. It's even easier to set this up. It's even easier to screw it up. You also don't have to state your business purpose in your certificate of formation. I still do this, mainly because I deal with a lot of partnerships, and it's best to have that disclosed and not run into it in the future, but there's no minimum requirement that that be in there. And then finally, you have to still maintain an initial registered agent in the state with a physical address. That cannot be a P.O. box. Last thing a lot of people forget about, you do have to pay a business privilege tax to the Alabama Secretary of State within 2.5 months of filing. Do not forget about that. A lot of people do. It will kick you out of good standing. Maintaining the LLC, no big changes here. Still have to maintain a registered agent in the state. Pay your business privilege tax. If you're a pass-through entity, you have to file by April 15th with the Secretary of State. If you are treated as some other non-pass-through entity, you have to file by February 15th. Minimum $100 based upon income. You also have to internally maintain listings of your members and when transfers were made, but there's no need to file that with the Secretary of State or the Judge of Probate. This is a common misconception. With LLCs, if you have a transfer of membership, you do not have to file it. However, it often helps. The old belt and suspenders approach does help here, so that you have somebody that might no longer be a member, and maybe you represent that former member and he does not want to have anything to do with that LLC. Might be worth it to register that change of interest just so it's on the record so that he doesn't get a lawsuit. Some changes on dissolution of LLCs. So the way that you actually dissolve an LLC is pretty simple. You execute an internal memorandum that says that we're dissolving the LLC, and then you file articles with the Judge of Probate. You then have to provide notice to creditors. So this is a big thing, or else you don't get limited liability company shields. But you have to notice creditors. You have to give them at least 120 days to file a claim with the LLC. If they fail to file within that period of time, their claim is waived. It's basically expedited bankruptcy proceedings. The change, however, with the new law is dissolved LLCs can be reinstated. So you can have an LLC that closed up this year and in 2 years opens back up using the exact same name. The problem is that it gets reinstated the exact same way that it would have been in existence when it was dissolved. So you cannot avoid a legal liability by dissolving the company and setting it back up. The statute of limitations is effectively tolled. So effectively extended, I should say. Because of this, you're going to have some folks that think that they can get out of a legal liability by dissolving the company and say, hey, we'll wait the 6 years until that contract issue goes away and then we'll set it back up. No, still exists. So this is a big change. I don't really know why it's there. I can't imagine a scenario in which you would dissolve an LLC and want to reset it back up, but it's there. So if anybody knows of any good reasons why you would want to reset up a LLC, I'd be fascinated to know it. This is probably going to be the least used provision in the new law. Changes to the liability. It used to be that you had the changes to third parties really haven't changed a whole bunch. The only real big difference is there used to be a specific provision that if the LLC had the requirement for a capital call, that you could go after that money. So it was a way to kind of not necessarily pierce the corporate veil, but at least expose yourself to a potential member. Say, for instance, you got into a contract action. You had somebody that needed a capital call in 2 years or something like that, and they didn't have the money to pay for it. Technically, you could put a lien on that future capital call. We've taken that provision out. It's probably still in there in an implied context, but it's been removed from an explicit context. As I've mentioned before, the liability that members have to the LLC, you still have an explicit duty of loyalty and care. If you do not set up an LLC agreement, you still have a duty of loyalty and care and of good faith. So it's important to think about that when you're setting up an LLC, that there are some still soft default provisions. However, we have, and we've also increased the indemnification rights. There used to be very specific provisions on what you could indemnify. We've expanded those so that you can, the LLC can indemnify a member much more. But the important thing to remember with the changes to the LLC is that all of these can be contracted around. The last thing that I'll mention is the change in direct and derivative actions. So this is, if you deal with internal business disputes, this is going to be a big issue. Direct actions are when one member sues another member for a duty that that member owes to the first member. Derivative actions are when you go through the LLC to sue a member for a duty that that member owes to the LLC. The reason that it's important to recognize these is because there's filing requirements on both of these, and they're different. If you don't follow the notice provisions and the filing requirements for both of these, then you will lose a motion to dismiss. So if you are going to file a direct or a derivative action for some type of internal dispute, make sure you're following the procedures. They're very explicit in the code. I'm not going to recite them. You can read them. But make sure that you're following that. You will get in trouble if you don't follow the notice and the filing provisions. One of the big things, obviously, is to notice that this is a direct or a derivative action, how that's actually being filed, and who is filing suit, and how that's happening. Talk real briefly about series LLCs. Like I said, this is the biggest change to the new law. This is one of the things that I think is most attractive about the new law, even though there's still some uncertainty on the tax end. But I'll tell you briefly about how they're set up and how they work. So the code is right there. I'm not going to go through it. Y'all can read it. Basically, it says if you have an LLC that you want to set up, and set it up basically as a holding company, it can have subdivisions within the LLC that have different assets, have different business purposes, potentially even have different owners. You can set up each one of these and they can have its own little bucket of assets. And if anything goes south with that particular series, you can jettison it. It doesn't bleed into the other series. It's pretty beneficial for somebody that, say, for instance, the uses I've seen these most often, real estate investing. You've got one particular property that you want held by one series within an LLC, but then you want another property held under another series. That way, if there's a liability with one of those properties, it doesn't bleed into another one. I deal with a lot of series entrepreneurs. If they want to quickly set up a legal entity that can protect them on their new business idea, they don't want to go through the whole process of registering it with the state, filing a business privilege tax, doing all that stuff, so they can set it up internally as a series on their operating agreement, and they can spin it off real fast. All it is just an amendment to the LLC agreement. Very easy to set up. Practically speaking, the way that these typically will set up is, like I said, imagine a holding company scenario. That you used to have, the most complicated one I've ever seen had 42 LLCs working together. It was a bookkeeping nightmare. Still going to be the same bookkeeping nightmare, but now it's just a little bit less on the legal end. But imagine a holding company that has its ownership is to other entities. You used to have the holding company set up, and then you would have different filings for the actual companies that it owned. Now with a Series LLC, you just file one notice for the holding company. The other thing is that holding company can actually hold its own assets. So there's no restriction on that. So in here I have Frank's Discount World LLC, and it owns some real estate. And this real estate actually leases to Frank's Discount Tires and Frank's Pawn Shop. These are two completely different businesses that have their own assets, but they're set up as series within the LLC. The benefit is that potentially this significantly cuts down on what you've got to file with the state, how you manage documents internally, and potentially even your bookkeeping. So we're still waiting for this to shake out on how it's treated, but there's a very strong argument that you wouldn't even necessarily have to maintain separate books for each one of the LLCs so long as the transactions are adequately noticed between one series and the next. The other big thing is that we're still in a little bit of a tax limbo, but there is the situation, which we're still waiting for resolution on this, about whether or not you would have to file independent tax returns for each one of these. And there's a big push so that you wouldn't even have to file a separate tax return for each one of these. Caveat. Right now, you do. You got to have separate tax IDs numbers. You've got to file separate tax returns. But the IRS has signaled that they are considering allowing one filing for everything. The big issue is you've got to make sure that all of these transactions and assets are adequately cataloged in your books. So say, for instance, Frank Discount Tires leases space from the real estate owned by the holding company. All of those lease payments have to be cataloged from Series A to the Series LLC. And it's got to be cataloged both ways. We're leasing this is a contract, we're treating all of these in the same way that we would a holding company and its individual components. So don't think that you've got to skip on that. It's important to make sure that you've got some type of protection here, because if you don't, the same piercing rules apply. All right, any big questions on series?
How's the public going to know that you're an LLC if you're using Frank's Discount Tires Series A?
You have to notice. So say, for instance, you've got a contract that you're signing with a potential customer or a vendor. The same way that you would notice Frank's Discount World LLC on the contract, you would say Frank's Discount World LLC Series A. You just disclose it the same way that you always did. Series A is a shorthand. You can use any type of name as long as it's considered a series, but it defaults to the operating agreement. So for instance, if potential litigation pops up, the very first thing that you're going to want in discovery in any type of series LLC is the operating agreement. You got to have that because that's what's going to control. The other thing is you've got to notice it in the certificate of formation. If you have failed to notice that you are a series LLC in the certificate of formation, you don't get any of the benefits of this. You've written a very long LLC agreement for absolutely no reason. You don't get any of the benefit of it. You still operate as one LLC. But if you've noticed it in the certificate and you've got a provision for it in your operating agreement that controls how that series is run, all you got to do is notice it. Yeah.
Diagram, and you have a contract with Frank's Discount World LLC, Alabama Series LLC. No Series A, no Series B. Would you strictly be dealing with the real estate aspect of that LLC?
Largely, yes.
Okay, because you have not identified the real estate as a series.
No. The real estate is owned by Frank's Discount World.
Now, could you put that real estate as Series C?
And keep in mind, the way that this is set up is still as a holding company. So the actual members of the holding company might be somebody else, and the ownership of a particular series might be owned by the holding company. Okay? Yeah?
That kind of brings up a question. Suppose that I had a judgment against Frank's Discount World LLC. Is each series interest an asset of the LLC that would be something on which I could levy?
Good question. I don't know. This is actually one of the big things that we don't know is how the charging orders are actually going to work out. We don't know. I'd be interesting to hear. I'd be happy to follow up with you and do a little bit more research on it, but we don't know yet.
Don't have the situation, it just came to.
Yeah, no. But that's a common question. I've got a recovery against, I've got a valid judgment against the holding company. What if it doesn't own anything other than having subdivisions within the LLC? Well, then you might be SOL. So.
What if the operating agreement specifically limits liability of a particular series? Operating agreement controls that.
Only with those in privity to the contract. So obviously if you're a third party dealing business with the LLC, then you're not going to have a situation in which we're not liable to anybody for anything in the operating agreement. That's not going to hold up. So.
Can an existing LLC go back and amend its certificate of formation to become a series?
Yes. So the old 5 is still in existence for now. The only way that an existing LLC will be treated under the new 5A is, one, if they just sit around and wait until 2017, or if they amend to be treated under the new law. So you can still amend now, and it doesn't just surprise you're under the new law. You have to have a provision in there, we want to be treated under the new law, and we are going to be a series LLC. So when you actually file these, you file the article, you file an amendment to the certificate that says we are amending to be treated under the new 5A, 101, etc. And we are going to be treated as an LLC or a series LLC. And literally you can have that 2 lines on your, the minimum, you'd want to have more, but you can have that as 2 lines on your little Secretary of State form, have your members sign and send it off to Judge Probate. Now, what does this mean for choice of entities? Practically speaking, at the end of the day, our job as lawyers is to help people form their legal entities and protect their interests in the best possible way. So, practically speaking, what we're looking at is not just, I'm going to rubber stamp an LLC for your particular type of business, but which legal entity might be best for you. When we talked about that hub and spoke scenario, there's a lot of different legal entities that we could potentially look at. So you've got corporations, you've got partnerships, limited liability partnerships, LLCs, business trusts, you've got employee cooperatives. So there's a lot of different options that you have available. LLC is only one tool in your tool belt. Just make sure that's not the only tool, because we've got a problem. First things first. The possibilities of when people think about the legal constructs in a corporation or in an LLC. Corporations are fantastic because you've got a lot of default rules. You don't have to spend a lot of time fleshing out what your shareholder agreements are going to be, what your bylaws are going to be. There's some default rules that at the very worst case scenario, you kind of know what your legal liability is going to be, even if we don't ever get anything signed. The problem is that because those default provisions are there, they're oftentimes not amendable. You can't change them. And so it's a lot like Legos. I was a big Lego fan. You've got these little pieces that you can put together, but you're kind of restricted on what it's going to look like in the end result. So I hear a lot of folks that say, yeah, this is great. We can take an LLC and we can start from scratch. We can build this beautiful operating structure with multiple layers of different interests, and we can have different ownership and voting rights and distributions and who's required to do what, and we can do all of this. So I compare Legos to sandcastles. You have the ability to create these beautiful sandcastles, or you're stuck with these pixelated corporations. Practically speaking, doesn't really happen that way. Most people kind of know what they're getting into with a corporation, and they say, you know what, I'm going to set up a corporation. We have these rules. We're going to flesh these things out. We're going to sit down. We're going to plan them. We're going to draft everything. We're going to sign it. We're going to make sure all of this happens before we ever get started. With LLCs, they say, hey, I'll go to LegalZoom. And so they don't make these beautiful sandcastles. They take the bucket, they fill it with sand, and plop it. I'm good. Let's go do business and things. So, practically speaking, the issues that I see pop up, and it's more often than I'd like to admit, I see people that either never bothered to sign an operating agreement, never even bothered to have one drafted. They didn't know that they needed one. They started doing business, and their Uncle Frank said, yeah, I'll give you $10,000. I want 10% of your business. Sure. Nothing ever passes in paper except for the check. Uncle comes back and says, actually, that was for 25%. Well, what are we going to say? That operating agreement is implied or oral. So, practically speaking, when I see these, I see people make a lot more effort in building out their corporation. And on an LLC, they're saying, you know what? I filed it with the state. I'm good. Practically speaking, it's not what you want to be doing. When you're choosing whether or not to go with an LLC or a corporation or some type of other legal entity, I often call an LLC a bracket legal entity. It is fantastic at the very low end, the small end, and it is fantastic for the high end where you want to have complicated investment structures, investing schedules, and distributions, and voting rights, and capital calls. But practically speaking, for most of the businesses that are in the middle, an LLC is a terrible choice. There's simply too much that can go wrong, and a lot of people don't take the time to flesh out what it's going to look like. So I call it a bracket entity. It's great on the low end, great on the high end, but in the middle, it sucks. The real big benefits, and we'll go through specifically the benefits that you have in an LLC, the big benefit that you have is your choice of tax regime. If you otherwise qualify for a tax regime, you can elect to be treated as that in an LLC. If you're a sole owner, I'm a disregarded entity, filing on my 1040, I'm good to go. Don't need to file a separate tax return. If I've got a partnership, we still want to be a disregarded entity. I don't have to worry about that issue. But maybe I want to be treated as an S Corp. Who knows? Maybe even a C Corp. There's a strategy that you would want to be a C Corp. You can do all of those things in an LLC context. The downside, the other benefits that you have is you can actually clarify classes of ownership. This will kick you out of S Corp qualifications. But you can say, this guy is a 10% owner in the company and has absolutely no voting rights. Limited liability, obviously. Unlike a general partnership where one of the members takes one unlimited responsibility, limited liability company has just as much protection as any other type of corporation. Another common mistake. Lower maintenance. You don't have to file stuff with the state. We're kicking Frank out. We're sending him a letter because that's in our operating agreement. We don't have to notice the state that we've kicked Frank out. Pass-through taxation, like I talked about before, by default, an LLC is not taxed as a separate entity. You don't have to do a thing. And you get the benefit of having a pass-through tax entity with legal liability limitations. The other benefit is that it's treated as an entity separate from the owners. So when you get sued, the LLC gets sued. You can say, actually, I had nothing to do with this transaction. It was my LLC. And you can use the LLC as the proverbial landmine. If somebody steps on it, it blows up. Nobody wins. You don't get a recovery. I'm judgment proof. The other benefit is that with other types of schemes, you often have to have multiple individuals involved. So think limited liability partnership. You got to have a partnership. LLCs can be founded with only a single member. You can also limit the rights of somebody's interest sale to a third party. So you're not getting into a business with somebody that you don't know. Partners get into business and say, listen, I don't want a scenario in which you get divorced and your ex-wife or your ex-husband now owns a quarter of the company. Completely legal. The biggest advantage is flexibility. You can do whatever you want in an LLC, and even more now, with very few exceptions. Now on to the downsides. Big thing is no statutory requirements for what the operating agreement is going to contain. You do still technically have to have an operating agreement, but what's in the operating agreement is not governed by the law. You can exempt the law in your operating agreement. If you're trying to raise institutional or early stage capital, it can be very difficult to invest in an LLC. The reason is the flexibility. People that are looking to invest in a company don't want a whole lot of variables involved. I understand what a corporation looks like. I want to become a shareholder. I don't know what your Series B Class 2 designation means in an LLC. I'm just not going to invest. Alabama has a business privilege tax. You got to file it in order to maintain good standing. It is a tax. You got to file it every year. It's a minimum $100 fee. It's not that bad, but it's a very good little insurance policy for if you're running a business. Not all states do have a similar similar tax though. You also get the benefit of having non-traditional management structures. Like you said, like we talked about before, with corporations, you had to have separation between the shareholders, the directors, and the officers. One person could wear many hats, but they had to divvy that up. With an LLC, you can have members that operate the business. You don't have to have a clarification on what that is. You can set up somebody that's not even a member to operate as a manager for the company. The other big issue is taxing jurisdictions outside the United States don't particularly love LLCs. They tax them as separate entities. So if you're going to be doing business overseas or if you're going to be doing business outside of the United States, you might still get taxed on a separate level. You can also create problems in the operating agreement if you have somebody that's the director of chaos. I've seen on an operating agreement before. You have no idea what that means. Does that mean that they can sign checks on behalf of the company? It's 100% dictated by the operating agreement. There's few default rule provisions like we talked about before, and there's very few minority shareholder provisions. If you're the owner of, if you're a 10% owner in an LLC, it's pretty easy to get hosed in these types of scenarios. But bottom line, the biggest disadvantage of an LLC is its flexibility. Like that sandcastle. You can do great things with it, but a lot of people don't spend the time and effort to get into it. So that hits kind of the big things. I'll field some questions if y'all have any. This is a fascinating topic. So yeah.
Yeah, given the 2017 date, aren't most existing LLCs going to need to go back and at least rethink, probably rewrite that?
Oh yes, this is a huge sales opportunity for all the folks that have been in here that have set up LLCs. Reach out to all those guys and say, hey, guess what? Your operating agreements are not really going to be that enforceable in 2017. Yeah.
Does the owner of a transferable interest, so he's not a member, doesn't have any management capabilities, he has no right to a derivative suit or direct suit at all under the LLC Act?
Well, it depends on what your definition of that transferable interest is. If he's not a member, if he's not a manager of the company, then technically he would be an employee. So no, he doesn't have. But under a traditional scheme, if he is, a 10% or something like that, then yeah, he could. But if he's an employee of the company or an independent contractor, no.
He owns the transferable interest. So let's say they're going to make a distribution, and for $10, and he owns 10% of the company, so each distribution should be $1. But he has no management capability because he's not a member, so he can't direct his affairs or anything like that. And so the members who can direct the company, they decide, well, you know what, I'm just going to keep your dollar, and I'm not going to give that to you. And he has no derivative action or direct action at all.
He would have a derivative action. So he would have a suit against the company saying that I am entitled to that dollar and that it was not distributed. So the company owes me that dollar. So just because, he doesn't have management rights, he still has a financial benefit from the company. So yeah, he would still be able to sue. And potentially he could add in a direct action against the other members, alleging some breach of good faith or something like that, saying that we're just going to hold this money and take it from you.